Today I am going to share with you about hostile witness. Now, what is a hostile witness? Hostile witness is a witness who is not friendly to the prosecution. Whenever a criminal case is filed, investigation is done by the agency, prosecuting agency, and charge sheet is filed. And during the process of investigation, there are many witnesses, statements are taken from many witnesses, and based on those statements, charge sheet is filed. And if the statement given by the witness to the investigating officer is different from the statement that is given to the judge in the court, then the prosecution calls him a hostile witness. That is to say, he is hostile to the prosecution. Sometimes there could be death of complainant also. In prevention of corruption cases, in a Neeraj Datta case, recently Supreme Court said that even if there is the death of the complainant, or even if the complainant becomes hostile, or even if the complainant is not available, still court can make out a case of corruption and decide based on the circumstantial evidence. Now, what is the circumstantial evidence? Now, fundamentally, evidence is of three types. One is oral evidence, where the person comes to the court and he explains to the court what he saw with his five senses. The second is documentary evidence. The document has to be proved and the document is brought to the court. The third is circumstantial evidence. There could be instances where there will be no oral evidence, there will be no documentary evidence. Then circumstance will also be an evidence. Circumstance will be proved because documents can lie, but circumstance cannot lie. Persons can lie, but circumstance cannot lie. So therefore, circumstantial evidence, circumstantial witness, circumstance as a witness, court decides cases even based on circumstances also. So when there is no oral evidence, because when there is a death of the complainant, or when the complainant becomes hostile, or when the complainant is not available due to reasons, many reasons, then what happens to the corruption case? Generally, in a criminal case under Criminal Procedure Code, if the complainant dies or complainant is not interested or coming to court, court acquits the accused. Unlike in a corruption case, Supreme Court in Neeraj Datta case recently created a principle wherein the death of the complainant does not abate the criminal case. Still the criminal corruption case can be proved by circumstantial evidence. So therefore, if the witness turns hostile in a corruption case, witness dies in a corruption case, complainant dies in a corruption case, still court will decide the case based on the circumstantial evidence. This is limited only to the corruption cases. Thank you. Thanks for watching. If you have any doubts, kindly comment.